Okay, hello everybody. Thanks for being here. This is Legal Strategies for Startup Success, or what else do we call it? Something to Legal Foundations. This
Legal
is session
foundations.
number, what was that, Don?
Legal foundations from seed to sale.
From seed to sale. And this is session 11 of 12, and we've talked about almost everything else. And now we're going to talk today about what happens when things don't go well, because every once in a while I'm told that a startup doesn't make it and they fail, and the founders have to regroup and start over. And so this is distressed startups or troubled companies. And my goal today is to give you enough background that if and when that happens, that you are able to go out and fight again, that you'll live to fight another day. And I will tell you that I've seen that happen over and over. I mean, wasn't it Abraham Lincoln who lost about 12 elections before he was elected president? Uh, I did have a client many years ago. He developed around 30 apps, and he just kept at it and kept at it. And the first 29 failed. But the 30th one ended up being one of the most downloaded apps in the Apple App Store at that time. It was a huge success. It's a unicorn. It's a multi-billion-dollar company today. And he never would have been able to do that if he had not planned into it. And I've seen it go the other way as well. I've seen people, they're just one and done. The first one fails and they go down with it. And I don't want that to happen to you. So with that, let's see if, yay. Disclaimer. So keep in mind, this is just information. It is not legal advice. I'm a lawyer, not your lawyer. You really need to talk to a lawyer for your specific situation. Now, with that, why don't we just jump right into it? This is a general summary. And again, this is a survey. This entire 12 sessions is a survey. So I'm only hitting the high points of all these things. I could easily do an hour on every one of these slides. And in fact, I have on most of them. If you want to go to my YouTube page and look it up, you can do a deeper dive on almost any topic here. So rather than recite the summary, I'm just going to get right into the meat of it. So first one, troubled company terms, because this in startup land, and keep in mind, and you should see a slide that says preferred stock terms. Keep in mind that all of these sessions are geared towards startups. And where this comes up oftentimes, most significantly and dramatically, is after you've got investors and option holders and you've raised some money and then something goes wrong. Maybe the market changes, maybe, I don't know, the technology has changed. Maybe you're a solar company and, a Chinese semiconductor company has decimated your industry, or maybe you're an AI, maybe you're a software company and AI has displaced, what you used to sell, whatever it is, but things don't go well. And what happens, first of all, to the preferred stock in that case? And here are a few scenarios, and forewarned, forearmed, all that sort of thing. So, first of all, what you would see, the company, say it runs out of money. It hasn't really hit its numbers. It's not doing well, but it can still raise more money because hope springs eternal. And, there are people that are willing to put money in at a different valuation or under different terms in order to turn it around. And it could be just bad planning. Maybe you just did not plan to take enough money to get you to that next valuation metric. Whatever it is, you're out of money, you're desperate, you need money, you go out and you sell preferred. Well, what's going to be different in that case? So typically, most preferred stock is what we call 1x non-participating. And we did a whole hour on this as part of this session. You should go back and watch that if you want to know what preferred stock terms are. But remember, 1x non-participating preferred, which is almost every deal I do these days, unless it's a troubled company. 1x non-participating means that the investor gets back the greater of what the money they invested, or their pro rata percentage of the company based on their share ownership numbers. That's typically what you see. Now, 20 years ago wasn't like that. I mean, it was just all over the place. It was just one of those terms that got negotiated. But the market is super efficient, and we've all kind of converged on that, except in the space of troubled companies. So what you will see with the troubled company, and it does happen. I just saw this deal maybe a month ago, is uncapped participation, or maybe capped participation. But the significant part here is participation. What that means is that the investor, instead of getting the greater of the money they invested or their pro rata percentage, they get the money they invested, plus they participate. They get a pro rata percentage of the proceeds of a sale of the company. Now, that is, when you see that, that is typically capped. And that's why I say capped or uncapped. Uncapped is extremely aggressive. Usually it's capped. So you get the money you invested plus a percentage up to maybe 2 or 3 times what you invested. And that would be, in a troubled company scenario, that would not be untypical. The second thing you'll see that's different in preferred stock terms in troubled company land is multiple liquidation preferences. And this doesn't come up nearly as often as monkeying around with the participation, but you might see preferred stock that basically says, look, our preference is no longer the money we invested. It's 2 times the money we get that first, and then we participate. Not as common. Cumulative dividends. Remember, in typical startup deals, dividends, which are distributions from the company out of earnings, are non-cumulative. In other words, if they're paid when, as, if, and declared, and if the company doesn't declare it, it just goes away. A cumulative dividend, which you see in almost every private equity deal, but not in venture deals, means it's like interest. An 8% cumulative dividend means that the investor just accrues at 8% a year after year after year until exit. You might see that in a troubled company scenario. Redemption rights. It's a right by the investor to force the company to repurchase its shares at a certain price. As a practical matter, if anybody ever exercises a redemption right, it's not because the company's doing great. It's because they want to become a creditor of the company and that way take over the company and liquidate it and get what they can out of it. Just so you know, that's how that would play out. You might see enhanced protective provisions. I have seen that. And you might see debt-like covenants. And I have had companies that have done this. They had covenants, they breached the covenant, and then they were in breach of the agreement, and that triggered all sorts of debt-like provisions. It can be pretty ugly once things start to go south, but it's super high risk at that point, and these are provisions that shift that risk from the investor to the company. The other thing that's the new stock that you would issue to a new investor. What about the investors who are on the cap table now? What happens to them when the company starts going south? Well, here are a few things you might see. Number one, they might, and by the way, you can usually, do all this by agreement. By a majority of the preferred stockholders can just agree to take all these actions. That's usually how these documents are set up. And they might just agree to reduce their preference, right? So if we got a 1x preference, maybe we would agree to reduce it or eliminate it altogether. If we eliminate it, we've effectively converted the preferred to common stock. Well, gosh, why would an investor ever agree to do that? Why would a majority of the preferred get together and say, we all agree by majority to amend our preferred stock to convert it to common? That's an optional conversion. Why would they do that? Well, they would do that because that might be the only way that they can hit that reset button, go back out to the market and get a new investor to come in and put new money in, or to get an old investor, existing investor, to put additional money in. Related to this, when you see stuff like that happen, you'll often see a pull-up, we call that, where we have new money that comes in, say an existing investor puts new money in, and its stock keeps its old preferences. In other words, it doesn't convert its old stock to common. It keeps the preferred if it agrees to put new money in. If it doesn't agree to put new money in, its old stock converts to common. And then this is a little bit different, but you'll sometimes see a reverse split. Usually I see, what a split is, right? We messed up on our cap table and we only authorized 1 million shares. and we realize everybody else is 10 million authorized, we'll do a 10-for-1 split. That's a split. A reverse split is just the opposite. And usually I see it as where we've messed up and we've authorized 100 million shares. So now we just look silly, right? So we do a reverse, a 1-to-10 reverse. So we get back to the 10 million. But sometimes you'll see a reverse split when the valuation goes up and then goes down. So maybe our valuation has gotten big enough where we can justify 100 million shares authorized, and then it drops way down. And now we can't, because again, our stock price is just so super low. So we'll do a reverse split. A reverse split is a dangerous thing. It really signals that there's something wrong with the company. Something did not go according to plan. So we really want to avoid that if we can, but sometimes it's the right thing to do. A little bit more on the pull-up. It's also known as a pay-to-play, and that's where the existing investors they have to invest on a pro rata basis, or they're going to lose their preferential rights. Okay, so it's kind of the flip side of the pull-up, right? And you see that most often in troubled company rounds. Companies out of money, and they need more money. Nobody wants to put more money in, so we penalize them if they don't. So you got preferred, and that usually applies to the future rounds. But keep in mind, like I said, it can be added to the existing round. I will tell you that I have had this happen, and I think I mentioned that before in this podcast, where I invested in a company about 20 years ago. Then we had the dot bomb, so maybe it was more than 20 years ago, and everybody suffered. And they did a pay to play and say, look, put more money in or you lose all your preferences. And I said, yeah, that's bad money after bad, or good money after bad. I'm not going to do that. What kind of idiot do you take me for? But other people did. And then the company recovered and went public. So public had a home run. And what did I get out of the deal? Less than I invested. I mean, because I didn't participate. So this stuff does happen, and sometimes you get a happy ending, I guess, for people.
Stick to being a lawyer, Roger. There you go.
Yeah, for people who, if you're willing to bet on a company, sometimes it works out.
Yeah.
Okay, the other thing about troubled company terms, you'll see differences. And remember, we talked during the preferred financing session about anti-dilution protection. And this is the idea that if I buy my shares for $1 a share, then you turn around tomorrow and you sell some of the same stock to someone else for 50 cents a share. Well, that's not fair. I mean, I should get some protection. And you may recall we talked about the 3 types of anti-dilution. Almost always in a typical financing, you'll see what we call broad-based weighted average anti-dilution. And to give you some perspective, that is the formula for broad-based weighted average anti-dilution.
Thanks.
And I'm not going to spend a lot of time. I'm just going to tell you it doesn't mean that my shares all of a sudden double. It means I get a little bit of a break, but that denominator is really big because it's broad-based. And I don't want to get too deep into the weeds on this. I'll just say that it's not a 1-for-1, right? It's just simply I get a few more shares. I get partial protection. That is pretty much the standard. Because otherwise, if you do the math, it means that my percentage would just stay exactly the same after the next financing, and nobody intends that. So, and then narrow weighted average means that we're just we don't count the option pool in the formula, in the denominator, basically. So the math works out a little more in favor of the investor. Troubled company, though, you will oftentimes see what we call full ratchet, and that is harsh. That means that the conversion price just adjusts down to the new stock price, the new lower stock price. And again, if you do the math, it means that I keep the same, as the investor, I keep the same percentage in the company after this new financing as I had before. Now, if you think that's bad, come on over to my neighborhood, because I do some foreign deals from time to time, and foreign investors will make it very punitive. They'll say, you know what, we want like more than full ratchet. We want double full ratchet, right? So instead of getting the benefit, okay, I bought it $1, you sold shares a week later at 50 cents. Instead of getting twice as many shares for my $1, I want 3 times as many. I want 4 times as many. I want to penalize you for doing that. And I have seen those terms. But again, Here in a typical US deal, you would only see stuff like that in a troubled company scenario. The other thing that happens when companies get in trouble like this, say the value has gone way down. Well, who else is getting hurt? Not just the investors, but you got a bunch of optionees, right? You got employees out there who are what we call underwater, right? They got an option, strike price is $1, stock is worth 50 cents. That option is worth nothing. So what are we going to do for them? Well, we could sometimes you do a top off grant or refresh and you give them more options. But more often, we'll do a repricing. We'll just reprice it at the new 409A valuation, reduce the option exercise price, and that just seems to be the easiest. It's not. There are some. It's not without legal compliance, right? Remember, Rule 701 is a securities law exemption. It allows the issuance of securities, meaning options or stock, under an employee option plan. A repricing is treated as a new grant. If you got ISOs, they're treated as re-granted. What does that mean? Start your holding periods running again. Kind of the sleeper here, though, is you also will have technically a tender offer. And I think we touched on this during the securities law session that we did, but you got to comply with the tender offer rules typically in a repricing. And then finally, we did a whole hour, remember, on accounting. A modification typically is, again, it's a regrant, and there's maybe a compensation charge. Not that a troubled company is going to care much about a compensation charge, but it's something to know about and pay attention to. Okay, let's turn to the drama part of the session, and that's the case law on some of this. So now we got a troubled company, right? And we've done all this recap stuff, or maybe we haven't. Maybe the board just says, screw it. Let's just sell this thing. Let's get out. My fund's coming to an end anyway. I'll just take my losses, take my tax deductions, lick my wounds, and move on. All right. So what happens in that scenario? And this one case here, Good Technology, was a few years ago. And I remember when this came up, let's just say I had some knowledge of this deal. They were not my client, so let me make that clear. But I was following it because I knew people that were affected by this. And anyway, so Good Technology, the allegation. So typical scenario, I wouldn't say troubled company, but I would say they got a sale to BlackBerry, and it turned out the ultimate sale turned out to be one that didn't do the common stockholders as much good as some of the other offers. Or that's the allegation. Some of the other offers that were turned down. So now we're all in litigation, right? And people are saying, well, gee, management, you push for a deal that supported management, right? Instead of pushing for a deal that maximized value for common stockholders. And that is going to be sort of the basic argument in this. It's a fiduciary argument. I'm going to drill down on this in a minute. But typically in these deals, if you think about it, say that, everything's underwater, everything's low value, the options don't have a lot of value. We want to sell, we have to incentivize management to go through with it. You're not going to do a deal if you don't get management to go along with it typically, or you won't get a very good deal. And so we do a carve-out plan. What's a carve-out plan? That's where we say, look, we're going to take some of the consideration off the top, and we're going to pay that to you, management, to get this deal done. That's a carve-out plan. And then some of the other terms you'll see in these deals is maybe we'll reshake some of the preferences, or we'll do some additional option grants. Raises all sorts of issues. Well, what kind of issues are they? Well, I'm going to get into that. I'm just saying in a typical sales scenario, this is what you've got. In the investment scenario, you might instead go the other way and say, look, we're just going to take more money in and sell stock to an insider. What are the issues there, right? You're on the board, but you're putting more money in the company. The value's gone down. You're getting in at a low valuation. Well, you can see how some of the other stakeholders might say, wait a minute, we don't think that's fair. You're on both sides of the deal, right? And you might add all of these other rights, maybe not just valuation, but all the stuff we just talked about. And And when that happens, there's really some key concepts to keep in mind, both in the inside around and the sale scenario. First of all, we typically have a business judgment rule that protects directors from any business courts. Delaware courts will not substitute their judgment from the judgment of the management, right? Unless it's conflicted. So if you're on both sides of the deal, well, then you don't get the benefit of the business judgment rule. And by the way, the beauty of the business judgment rule is that the shareholder has the burden of proof in that to prove that your judgment, there's something wrong with it. But if you're conflicted, you don't get that. You're in entire fairness. And we talked about this during our corporate law session in this series. But let me recap. Entire fairness means, number one, the burden of proof changes. So now this investor, I guess conflicted party has to prove that the transaction was fair to the company. And I know that sounds like a lot of lawyer talk to say, oh, burden of proof, who has to prove it? It's a big deal. It makes a big difference, right? Burden of proof is a significant factor. And plus entire fairness. I'm going to talk about what that means in a minute. Secondly, the other kind of concept to keep in mind, and you see this come up in the cases where, especially the option cases, where there's this concept that if you're on a board or if you're a controller, shareholder, you owe fiduciary duties to the company and its shareholders. Well, sometimes the shareholder will say, well, wait a minute, I got these contractual rights, right? My preferred stock gives me all these rights. I got all these protective provisions, right? So this is just a matter of contract. Well, not so fast. I'll show you what the courts say about that in a minute. And then finally, you will notice running through all of these cases, I mean, judges are not in a position to tell you what's a good business decision. So mostly they want to know that the process was fair. So backing up one, what do we see in an unsuccessful exit typically? Well, first of all, what we call zombie companies. They're just not going anywhere at all, right? Or maybe they do get sold and everyone ends up in litigation. So maybe to avoid that litigation, you'll put the company into bankruptcy. I'll talk about that in a minute here. Or maybe just sell the assets off, get what you can get, fire sale. So against that background, let me tell you about kind of the granddaddy case here. In this scenario is In re Trados, shareholder litigation. And I really like this case the more I think about it because it's got so much going on in it. But in that case, the board of directors, which was conflicted, of course, they adopted a management incentive plan because they wanted to sell the company, but they had to incentivize management. So the board adopted this plan that was going to pay quite a bit of money, right? $7.8 million to management under its management incentive plan. And that was enough where the preferred got most of their preferences. The managers got their $7.8 million. Common got nothing, right? Now, this doesn't just happen in law books. I had many years ago, I had a founder come to me who was so excited because they founded this company and they had just read in the paper, and then they, typical VC stuff. They got forced out and they went off and did other things. And a few years later, they read in the paper that the company's being sold for $500 million. And they thought that was so great because surely they're going to get, they're going to get a payday because they're the founder. They had a lot of stock. Well, you know what? So I went and inquired and got a hold of the lawyers for the company and checked it all out. And it turns out what the three founders of this company were getting out of that $500 million deal was nothing, was zero, right? How could that be? Well, it's because of the series of insider rounds that through a combination of increased preferences and full ratchet anti-dilution had pushed them down to nothing. So that stuff really does happen in the real world. And trust me, it's a pretty risky scenario for everybody to be involved in that because if it's insider rounds that got you there, then we're back in this entire fairness standard. And what does that mean? Well, first of all, that there's a fair process. And secondly, that there's a fair price. Now, Trados is interesting because the court, as I recall this case, the court said, look, this is an interested director transaction. You're out of the business judgment rule. You're in the entire fairness standard. And by the way, it doesn't take much to make it an interested director transaction. Don't think, I got another case, I'll tell you about that. But let's just assume that it's interested. You're on both sides of the deal. And, the process really wasn't fair. You didn't go out and get an investment banker, to value the company. You didn't really go out and test the market very well. Not a fair process. But it was a verdict that favored the investor because the common weren't going to get anything in any scenario in the sale. So kind of a Pyrrhic victory there, but it gave us a lot. It gave us a lot in terms of guidelines. Now, going back to good, which I had talked about earlier, the reason I'm citing this case here is mostly because of this quote by the court. It says, gee, this decision was motivated by the fiduciary's economic interests, and they were way more risk-taking than another fiduciary would be. The other thing about this that struck me is, again, just, again, they're saying, look, we got all these contractual rights. Doesn't matter. Fiduciary rights survive here. More to the point, Carsonero versus Bloodhound Technologies, another really good example, a good roadmap of how to do these things. This company went through multiple rounds of financing. Same thing, management incentive plan. We got to incentivize management to go along with the sale. And then there's an allegation that, wait a minute, that sale really was unfair to us. Founder and employee said it's unfair to us common stockholders. You diverted all this value to the preferred holders and management. And the court allowed those claims to go forward. And the thing that made it an interested director transaction is the fact that the board, they felt, were under the thumb of the investors. Why was that? Because part of the deal was the board was going to get, participate in the management incentive plan if the deal closed. So now they're all in cahoots with each other. So my rule of thumb on these deals is just assume that everybody's interested, because someone's going to make that allegation, and a court might go along with it. It doesn't take a lot to be within that standard. Oh, and then the other thing that was interesting is how they just dismissed that contractual rights claim and said, look, yeah, you got contractual rights, but that doesn't mean you're not a fiduciary. All right, so what do we get from all of this? Best practices. Understand that the board has duties to everybody. That's common and preferred, despite your contractual rights under the deal documents. It'd be best if you had an independent board. If you can't, at least get an independent committee to approve a deal. Just assume typically that you're going to have to satisfy the entire fairness standard. And probably the most important thing, run a good process. What does that mean? Oftentimes it means going out to an investment banker and getting a fairness opinion, or at least go out and shop. If you're doing financings, go out and shop it and solicit other term sheets. Just go to market. That's a good process. So some good direction in these cases. So other unsuccessful exit issues to keep in mind are, okay, we're on slide 18. I'm going to dive into these in more detail, but tax liability, personal liability, etc. Now, I do want to mention Section 382, speaking of taxes. And this is probably not the best place to put this slide, but we're here, so let's talk about it. Because oftentimes companies will say, gee, you know what, we've been losing money for 5 years and we're just not going to make it, but we got this big valuable asset. That's our tax losses. We'll just go sell our company because somebody else might want to buy a company just to get our NOLs, our net operating losses. And that's the way things used to be before I started practicing law. That's how old, that's how long it is. It's not how it is now. 382 restricts the ability of that buyer to use the losses of the seller, because Congress didn't think it really made a lot of sense for people to be out selling their tax benefits. And by the way, this comes up, I could do a whole hour on 382, and I have, because it comes up not only in sale, which is the obvious case, it comes up in financings, because if you trip over that change of control, measure in financings, and all of a sudden the company in current year can't use the losses that it's trying to carry forward from a past year. So this is a real issue. It's why I have it in here. Second thing in a sale that is worth thinking about, because this just looms large as well, is the WARN Act, Worker Adjustment Notification Act. So if your employer has, in California, has a counterpart to this, if the employer has enough employees, they have to give advance notice of mass layoffs to the employees. So this is something we always see whenever we have a shutdown. I want to talk a little bit, because we're in 2026, about two other provisions that are fairly recent. One is the SBA program. And you'll know that, you might remember during COVID, we had our PPP loans, our SBA, what was it, Paycheck Protection or something like that? What was it, Paycheck Protection Loans? I can't remember what it stands for anymore. It's been so long. But almost everybody got one of these. And when I say almost everybody, I mean including people that were not entitled to them. Massive fraud. And the SBA, took them a while to get around to it, and they're going back after those frauds. Now, Joe Biden made this a priority. He extended the statute of limitations, or it extended under his administration, to 10 years to go out and prosecute these and audit these. And it is heavily audited. And my firm actually has a department that deals with this almost exclusively, because it is such a big area. And I will tell you, dealing with the SBA on this issue is not easy. It's not for the faint of heart. I mean, they do look very carefully at these, and this is going to go on for quite a while. And by the way, I don't know if you all heard the president's State of the Union speech last night, but I listened to it until I fell asleep. But before I did hear him say that Vice President Vance is going to oversee a new fraud division within the executive branch. I think they're talking more about what went on at the state level, but I kind of wonder if it might not include additional enforcement of things like the payment protection provisions here, the SBA loan provisions, because it is just well recognized that there was tremendous fraud. Similarly, during COVID, we got this credit, right? The ERTC, Employee Retention Tax Credit. And pretty much if you didn't, and you were eligible if you didn't get, if you didn't have SBA loan forgiveness. So I will tell you, I won't go through this whole slide. I'll just say that this is an area where the IRS has been very active. Even though it's underfunded, this is one area where it is still doing its job. And it is really going after these fraudulent ERTC claims. And it's a little unfair if you think about it, because this was by the way, same with the SBA loan program. These laws were put in place hastily, quickly. They are poorly drafted. They're not well understood. People made lots of mistakes. And the IRS, in this case, deemed a lot of those to be fraudulent and has gone after them. It's 28,000 disallowance letters, 500 criminal investigations, and just recently, the IRS is. I'll give you my personal experience, because I had a law firm about the time this happened. I got the SBA loan just like everybody else, but I decided I was going to be a good guy and not ask for loan forgiveness, because I pay my debts. But I'm a good guy. I'm not a chump. That means I get the tax credit. So I applied for the tax credit, hired a tax firm to process it, because I don't want any BS about it from the IRS. Keep us all above board. Cost me a fortune. Processed it 4 years ago. And I've been waiting and waiting and waiting. And recently I get a letter from the IRS says, oh, fill out these 20 pages of questionnaires. We got a lot more questions. And this is a real problem, not just me, but this is a real problem in the system, is that these things are just not worth the trouble for most employers. You have to be a bigger company before it's even worth the administrative cost, time, and expense you have to go through. So the fact that the IRS is underfunded is not just affecting. I mean, some people say, "Gee, taxes aren't being enforced and people aren't paying." Well, you know what? They're not being refunded either. So anyway, that's my aside. Okay, some defensive operating strategies in a sale when you have a troubled company. Number one, avoid personal liability. We'll talk more about that in a second. Minimize your taxes. Well, I'm going to talk about cancellation of debt. Use the laws that are in place to protect you and then manage your risk, manage your cost. So let's, before I jump into that, well, this is a good defensive strategy. This is one where we're managing risk. So typically you have a startup company, you'll sign kind of that standard invention assignment that you downloaded online that says you own everything I create related to the company. And if it fails, well, I guess you get that too, you, the company. Well, not so fast. Let's suppose we do this structure, which I have done. And I've done this more than once. And sometimes you got to talk, the investors into it. You definitely got to be upfront and transparent. But just imagine that your inventor doesn't assign the technology, they license it for a field of use. And I've had it happen more than once, where we license it to the company gets funded, company fails that space. It just doesn't work in that vertical. License the same technology to vertical number 2, company succeeds. So our inventor is a millionaire. Now, suppose that they had just assigned it to company 1. Well, company 1 would have failed and IP would have gone away and nobody would have made any money. In this way, it's only the VCs that get stuck and the inventor lives to fight another day. So something to keep in mind. Related to that are some of the IP holding structures we put in place just for this reason, for liability isolation. We got IP sitting down here because why do I have that in a separate company? Well, there's a lot of reasons. It could even be tax, but the biggest reason is suppose there's an infringement claim, suppose there's some sort of IP claim. I don't want that to bring down the entire operation. Alternatively, suppose there's a liability claim against the operations that don't affect the IP. I don't want that to end up bringing down the IP. So we use these companies where we isolate them. And this is a very common standard structure. People give it a little thought. Yeah, I said I would mention guarantees. So given the time, I'm not going to go through all of this in detail, just to say that typically where people get in trouble with these companies is they'll sign personal guarantees or related to this, sign up to potential recourse. So for example, a bad boy guarantee could also be bad boy recourse, right? So a straight guarantee is very simple to understand. Company enters into a lease or enters into a loan agreement, and if it doesn't pay, I've guaranteed that debt. I, the owner, I'm the guarantor, I have to pay. A springing recourse guarantee means that something has to go wrong at the company before I pay. Bad boy guarantees a company has to have done something wrong, and then I'm obligated to pay. Well, it's the same with recourse. And trust me, your lender is going to be looking really hard, to find that something you did wrong. And it could be something you might think is fairly innocent or simple. I mean, I could tell you stories, but for example, maybe you make a mistake on the loan application. Or maybe just look at this long list. Maybe you've made a distribution from a company you shouldn't have. So you need to be really careful about guarantees, because the best rule is never to sign a guarantee, because I never would. But if you do have to sign one, try to get springing or limited recourse. And if you do have to do that, then be very careful about what will cause that guarantee to become effective. By the way, I started my career, 40 years ago. I used to represent banks, and I'd also represent debtors on the other side. And I've litigated guarantees. And you might think it's pretty straightforward and simple. It is not. If you think that, then you have not lived, because there are a million defenses to guarantees. Those cases always tend to be pretty interesting and involved. Force majeure. Speaking of the old days, when I was in law school in the mid-'80s, I remember reading about this thing called force majeure, interesting legal theory, got out into practice, and we all popped these little force majeure clauses in the back of our contracts. We talked a lot about this in our contract sessions. I won't belabor it. and then didn't think about it again for 40 years. And then COVID came along and we all became experts on force majeure. And now we put a lot more thought into these contracts. I don't think until COVID I ever saw anybody trigger one of these. I mean, how often do you see acts of God, war, terrorism, disaster? More often these days than before, I guess. Impracticability, we talked about all these during the contracts session, so I'm not going to belabor it. I will say that if you can get business interruption insurance, we saw from the from the shutdowns that is a good thing to have. I understand not many people get that, but we can see the value of it. But business interruption might be a nice to have. D&O is a must have. It is a must have in the current environment, whether you're in California or not. This is directors and officers liability insurance. And that means when you get sued, for being a good fiduciary that you thought you were, but somebody doesn't like a decision you made, the insurance company is going to defend you and it's going to pay the claims. Now, the D&O insurance should go alongside a very well drafted, careful indemnification agreement, which will provide a lot of direction as to just what the process is, how you submit claims, who gets to choose the lawyers, what happens if there's a settlement, on and on and on. So, I put a little thought into that as well. I want to pause on what we call fraudulent transactions. I guess we don't call them that anymore. That's not the current nomenclature now. It's a voidable transaction, but it's the idea that a creditor can avoid the transactions if can avoid a transaction that is made to a transfer that is made to defeat their claim. Now, do you remember 4 or 5 years ago that show on TV? I think it was called Tiger King or something like that. Those guys down in Oklahoma who had these big tiger sanctuaries, and he got in there. So they were competitors, and there was this big dispute, and I think he got sued for defamation. Oh no, it was trademark infringement. Anyway, big judgment against the Tiger King, who's now in prison, and he to avoid that judgment, he had this bright idea. He transferred all of his property to his mother. And he did her a heck of a favor because all he did was drag her into the lawsuit. So she gets named as a defendant. Now she's being sued. And the whole thing was unwound under this Uniform Fraudulent Transfer Act because it was either actual fraud, you transferred it just to avoid paying me, the creditor, or it was constructive fraud, meaning that you didn't have enough money to pay me and you didn't get a reasonably equivalent value when you transferred it. So just keep in mind. And by the way, in California, as well as many other states, it's a crime to do this. So don't ever get involved in a fraudulent transfer or an avoidable transaction, I should say. Taxes, trouble. This is kind of, I probably should have led with this because this is the first thing that comes up when a company starts to get in trouble. The first thing they think is, you know what? I've been making these regular payroll deposits. I think I can't do that. I need that money to pay my employees or the leave. I need to pay my landlord or he'll evict us. It's just impossible. I can't make the federal tax deposit. So they just use it for other purposes. Well, that is personal liability. Personal liability for any responsible person. Now, before you think, well, that sounds like a high standard responsible person, let me tell you, it is not. The IRS views that extremely expansively. And I've been involved representing companies where they've gone after everybody in sight. The bookkeeper, I'm not kidding you, they've named in these things, and then you got to fight your way out. So just keep in mind that this is super serious stuff. It is the last thing in the world that you want to not pay are payroll taxes, because the IRS views that as their money from the start. It's not that you're paying them something you owe them. So you're holding, they call it trust fund taxes, because you're holding their money in trust. You've withheld it from money you would have paid the employee to hold in trust for the government. Similar rules for state as well. And these cases can be prosecuted criminally. It's probably the first time in this 11 months that I've had to talk about criminal law, but there you go. Other taxes, California sales tax, there's potential personal liability, unemployment, workers' comp, disability, potential liability. One thing I will say, speaking of criminal liability, is workers' comp is where you have the highest risk of criminal prosecution. I don't know why, I just know that it is. Because, well, it just is. It's right in the statute. Other place where people get in trouble, bad checks, credit cards, as you might expect. Here's one that you might not expect is improper distributions. And the law in California, at least, provides that a shareholder has personal liability if they get a distribution that they shouldn't have. And that would be generally, I mean, there's a formula in the statute that we all kind of struggle to understand, but generally, it means that the company is paying you the shareholder distribution instead of paying its creditors. And there are some numerical tests, retained earnings tests in the statute, but it's something to keep in mind. It doesn't come up often because my clients don't pay dividends. They just hold and hold and hold and then sell. All right, wages. Here's a surprising one. In California, if you cause somebody not to be paid, if you cause your company to engage in what we call wage theft, right? You have them work and then you don't pay them. Well, the response, again, the person acting on behalf of the employer can be held personally liable. And I'll tell you that the Labor Department will go after you for this. And there's a private right of action there as well. So the employee could go after you. Another sleeper, and I might have mentioned this before, in this case, is the Department of Labor. You have a 401k, you have an ESOP, you have some sort of benefit plan. You, the employer, are typically a fiduciary of that plan, or you could become a fiduciary. And that means you might be taken to task on any decisions that you make. And if you've ever been on the other side of the Department of Labor, I will tell you that you might think, well, they're like the IRS, they just want to get paid. No, they're like an avenging angel. They want their pound of flesh. CERCLA, this is the Environmental Protection Agency. We all know about CERCLA claims. Responsible parties can be personally responsible. And by the way, these numbers can be humongous. So I've seen lots of really sad stories over environmental claims. And usually it's in real estate because anybody who touches title is going to have to be worried about this. Fraudulent failure to pay. This is another one that surprises people because we all think intuitively that, oh, if you don't pay your company, we created this company so that I won't be personally liable if the company fails. Well, okay, that's true. You won't be liable for any contracts the company breaches. So it buys products, doesn't pay for it, the vendor sues the company, not you. There's an exception to that. Let's suppose the vendor says, does your company have enough money to pay me? And you fraudulently say, oh, of course it does. And then, so they deliver the product, company doesn't pay, vendor now comes sues you for saying that for fraud. And that happens regularly. So don't think it doesn't. In fact, I talk about that. I talk about all this stuff in much more detail in my book. And this happened on an episode of The Sopranos way back. It's a long story, but you can read about it in my book. But they had a whole episode where one of the subplots was right along somebody being sued for fraudulent failure to pay. And then, of course, there's all the statutory claims. We kind of beat up the securities law stuff enough earlier, so I won't go through it again. I do want to mention that there are statutory fraud claims, federal fraud claims, bank fraud, wire fraud, and securities fraud. So it's not just a state fraud claim that you have to worry about. And then here's the one you will all hear about so much, the alter ego claim. So first, let me just say that in all my years of practice, I have formed thousands and thousands of companies. Because I do startups, most of those have not succeeded. It's a volume business, right? It's a numbers game. Most have not succeeded. And that means they have failed owing somebody money. Never once. I can count on one hand a number of alter ego claims that have been made against those companies. Never once have I seen one succeed. So that's just my anecdotal experience. Now, I've talked to judges who hear these claims, and they see it all the time. And what's the difference? Why is it that my companies never get sued for this or never lose? But it happens all the time. And really, it's a matter of, two things. One, respecting formalities, right? Getting all the right pieces of paper in place, segregating your bank accounts, having all the right pieces, just doing your minutes, doing stuff properly, which is what I would do if I formed a company. And then secondly, it's where does the money go? And well-counseled companies are going to make sure that, because typically a creditor is going to follow the money when they want to collect under an alter ego claim or any other kind of claim. We talked about fiduciary claims. What I would add to that is once a company becomes insolvent, the directors owe duties not only to shareholders but also to creditors. So think about that. Suppose a company's insolvent. That means there's nothing left, right, for the shareholders. There's not enough value. But who you're working for then? You're working for the creditors. Well, then you owe them duties. And lots and lots of law about this. I'm going to skip over, well, I'll just say two things about taxation because we're running out of time. Cancellation of debt. If a company has debt and it gets it forgiven or reduced or compromised, there's cancellation of indebtedness income. It makes sense, right? I owe you, $100 and you agree I don't have to pay you. I've got $100 of taxable income. Without getting too deep into this, I could do an hour on this. I will just tell you there are so many exceptions to this and so many ways to plan around this. In 40 years, I have never seen anybody pick up cancellation of that income. We can always fit within one of the exceptions, and I won't go through these because there's too much there. And that gives me time to conclude with insolvency proceedings. 5 minutes on insolvency. Again, if you go to my podcast, you'll find hours on this stuff. I have a whole hour on assignment for benefit of creditors. That's like a state law alternative to bankruptcy. And it allows you to do what is essentially a bankruptcy. You get the same result with very similar law hopefully without as much expense. And this is still done when companies get in trouble. But if that doesn't work, we got bankruptcy. And why would a company go bankruptcy? Think about that for a minute. We went to all this trouble to have this company here to protect me from personal liability. If it fails, most of the time, the shareholders just walk away. It's like, look, you can go sue that empty shell of a company all you want. I'm gone. I'm out of here. And usually that's the right answer. But sometimes it's not because there's so much going on in the company that you want to get those claims resolved in a courtroom. Maybe you want the protection of the court to collect on claims. Maybe you want it to sort out claims. And I've been in bankruptcies where, in fact, I was involved in one big bankruptcy where every creditor got paid in full. So sometimes these things can work out really well. Liquidation, the business just stops operating, just sells everything it has and pays its creditors to the extent it can. Reorganization, Chapter 11, usually debtor in possession. Sometimes you get a trustee appointed, but usually the debtor just continues to run the business and they get a little bit of breathing room. What I mean by that is they get an automatic stay. That's an automatic injunction that halts collection efforts for a period of time. And a couple other concepts to keep in mind if you're thinking bankruptcy is payments made to a creditor. That's a preference within 90 days before the filing. And the idea is you shouldn't be able to just immediately pay somebody file bankruptcy so this creditor gets paid and that creditor doesn't. So any payments within 90 days or 1 year for insiders, they get clawed back into the bankruptcy and reallocated. Then there's their own law fraudulent conveyance in bankruptcy that could go back and go after creditors. And the big thing to take away here is we've talked about fraud because sometimes when companies get in trouble, people will get desperate. And, you don't want to do tax fraud. You don't want to do SBA fraud, but you certainly do not want to do bankruptcy fraud. I've been in cases where people have done that. And I can tell you that that is not something that anybody wants to have anything at all ever to do with because you are under the scrutiny of a court. And the court is looking at every little step. And it's actually kind of surprising just how much a bankruptcy court will substitute their judgment for yours, especially when it's something that looks fraudulent. There's a priority scheme, as you might expect. There's a credit, and under that priority scheme, the secured claims get paid to the extent of value of their security. Administrative claims have to get paid. If there's anything left over, it goes to pay the unsecured creditors. And usually the equity gets completely wiped out. If there's anything left over, it'll go to the equity. And then finally, I'll just mention that the creditors committee, the court will appoint a committee of unsecured creditors, which is kind of interesting because you might have people that come, maybe you got a debt holder sitting next to a vendor. So they're come from completely different, or next to a tort holder. Remember this big case recently, this big tort claim against the company that was manufacturing the drugs that hurt a lot of people. Well, they had a creditors committee that had all these different constituencies, and they, that's the, they have to get together and provide oversight and investigation. And oftentimes creditors will want to get on that committee so they can push the claim through. By the way, the creditors committee does get a chance to examine the debtor as well. And sometimes that could be pretty unpleasant for the debtor. Okay, with that, we are at the top of the hour. I am Roger Royce. I want to thank you for being here. Here's my contact information. This is the 11th in a series. We'll be back next week where we are going to talk about our final session of the series. And next month. And the final session, I was going to do a Q&A, but I think instead I'm going to do a case study. We're going to take a company from start all the way to finish, from formation to exit, from seed to sale, as Don would say, or an happy or unhappy exit. And you can kind of see how this all plays out through the lifetime of a company. So thanks for being here. The recording will be available on YouTube and through the podcast. The slides are available for anyone who wants them, and you're welcome to have any of my materials on this. Just shoot me an email. So with that,
Roger, thank you so much.
This
is so much information, even after decades in the Valley.